Thank you for joining us on this episode of the Real News Extra. My name is Fred. I'm the operations manager here at Relaw APC. And joining me today is the principal and founder of Relaw APC, Jennifer Felten.
Hello.
Hi, Jennifer. So this month's case involves arbitration. Mm-hmm. What brought an arbitration clause case to the court?
Okay, so if you want to cry, read this case. It really is just a really sad situation where an elderly couple in their 90s was solicited by a company to do improvements on their home.
Okay.
And there are companies out there doing this right now. It's not illegal, but the question of whether they were the right candidate, whether they should be getting this loan, whether this was something that was in their best interest, are all questions that we struggle with from a professional standpoint on situations like this. These people were living on Social Security, had no financial means to be able to repay a loan, and yet were solicited, and the question of the case was whether they actually signed a contract and agreed to the terms of this loan, and in so doing, then agreed to arbitrate when a dispute arose. So the consumers claim they did not understand. Both the gentleman who was the signer and his wife are, again, in their 90s and have dementia. So the question of capacity was at issue. But further, the contract was signed via DocuSign on a cell phone of the daughter, where the dad doesn't have an email address, doesn't understand electronic communications, and we have a DocuSign that was signed in less than a minute with a 33-page contract, right? So lots of questions and concerns about efficacy, viability, and the validity of the contract. Unfortunately, the company started working based upon the contract, and then once the consumers kind of figured out what was going on, they stopped working because the consumers said, we're not ready, willing, or able to pay this loan. And the result was that these people were living in a house with a demolished bathroom, right? I mean,
yes,
it just gets worse and worse and worse as this story goes on. So the question presented to the court was, the consumer sued, right, saying that this wasn't a valid contract. We don't believe we're obligated. The company sued to enforce the arbitration provision and say this dispute needs to go to arbitration. And so the question before the court was whether the arbitration clause could be enforced. And the trial court said it couldn't based upon some of those factors, whether the dad, the owner, signed the arbitration clause because it wasn't his phone, it was DocuSign, whether he had capacity. All those issues were at issue, and the trial court found that it wasn't an enforceable arbitration clause. The company appealed, and the trial court agreed. On all those same grounds relative to validity, they determined that the arbitration clause was not enforceable.
So how does both competency and computer literacy impact the validity of electronic signatures?
Well, so California has actually an electronic signature law.
Okay.
And for people like me who we're doing business more and more in a electronic way, I'm a big fan in general of electronic signatures, and it allows business to move quicker and easier and avoids this big bad word friction. That is the thing that slows things down, right? So I'm supportive in general, but the e-sign rule specifically requires that you have an email address and to be able to contract via
how do you
DocuSign,
transmit it?
Right? So in this case, I agree with the court that this was not an enforceable contract. There were a whole bunch of cases get real complex. It was the daughter's phone. Did she do it? Did she have authority? Was she an agent? Like, questions start to go beyond and beyond and out and out. But at the bottom of the line, the California law, to be enforceable, the person has to have an email address to sign via DocuSign, right? So without it, I agree that there was not an enforceable contract against this couple in this situation.
So what are the broader implications that this case has both for contract enforceability and electronic signatures in the current era?
Right. So as we're trying to move into a more digital age, we're going to have to still realize the limitations of what technology can do, and the limitations of who we're dealing with, of whether they understand and appreciate and know the technology.
Yes, of course.
And so when you're like, we have potential clients who come to us who tell us they don't have an email address. So we've tried to streamline our process so that our retainer agreements are sent out electronically and we collect our retainer fees electronically. Well, if someone doesn't have an email, we're going to have to physically send them paper. They're going to need to physically sign it, and we're going to have to get it physically back. Now, there are still some ways to, with help, to make that simpler and easier, but that DocuSign's not going to work. That is not going to be the way to get a provable, valid signature from someone. So as we're pushing forward and moving into technology, we still have to make sure that, do people understand? Are they able to contract? Is the contract going to be enforceable? And so all of those considerations in the rush of business still have to be considered.
Yep, good information. Thank you. And thank you for joining us on this episode of the Real News Extra. If you're enjoying this content, I invite you to click on like or subscribe and to click on that little bell for future notifications. My name is Fred, and I look forward to seeing you on the next episode of the Real News Extra.